do have skills that make me a nightmare for people like you.
Okay, so 19th of March, a 6-page response no less from the head honcho, John Strawbridge, ex-police detective, owns a few bistros in New Zealand, used to manage Eden Park. This is the response to my follow-up questions in regards to the 12 infringements, trying to get a meeting with them, etc. And it reads as follows. Dear Mr. Keane, LGOIMA 1987, the Goima Act, CAS-965373-C6F3Y5. Thank you for your email dated the 18th of February requesting further information about infringements issued outside the Waitakere District Court, Ratanui Street in Henderson. Email dated 18th of February responding to Rick Bidgood and Deepa. 1. Excluding your unlawful ticket issued to us, that leaves 9 unpaid. What is the status of those other 9 infringements? All outstanding infringements have been passed on to Bay Corp, not due process of law through a court, no, straight to Bay Corp, to follow up with payment before infringements are sent to the Ministry of Justice. So they'll try Bay Corp first to get people to bully up into paying and threaten their credit and their credit scores, instead of actually doing due process, which should go straight, just like a speeding ticket should, it should go over to the Ministry of Justice for a hearing. Instead, they throw it to Bay Corp. 2. Will AT be refunding the 2 that have paid? If not, why not? No, the infringements have been issued correctly. We'll see about that on the 1st of April now, won't we? 3. Will AT be voiding the other 9 excluding ours? No. 4. I have been in direct contact with one of your parking wardens who informed me that AT made 85 million last year and not 8.8 million as you report, who is not accurate. Your request was related to parking infringements, underlined. This information was provided in your letter dated 14th of April. Okay, so in other words, the 8.8 million is only related to parking infringements, not labels affixed improperly, not other special vehicle lane offences, but only parking infringement offences, okay? 5. Also, we have had no response on the below case number, still outstanding, from the 24th of December. A response was sent to you via this case email on the 19th of February at 9:52. Okay, now let's see here. He's saying a response was sent to you regarding this case via email on the 19th of February. But he's responding to the letter that was what? Email dated 18th of February. So I hadn't received it then. Ridiculous. Email dated 18th February responding to Rick Bidgood. 1. What dates were the other 11 infringements issued? 1. 4th of October, then there was mine on the 12th of October, 23rd of October, 26th of October, 13th of November, 16th of November, 19th of November, 26th of November, 2 infringements issued, 30 November, 17th of December, and 19th of December. And they only have 1 infringement issued on the 19th of December, when I know for a fact I had a witness watch them issue at least 2. So, again, it's not really all the truth I'm getting told here, is it? 2. Which wardens issued them? Just the number, no personal details required. Wardens number 1165, 1065 and 1058, along with Warden 1126 who issued ours. 3. Why did no warden call this fault in? At the time, the officers had no reason to believe that there was a road marking fault, so they can't see white lines with broken yellows. They suffer from the same visual problems that apparently Rick Bidgood suffers from. 4. Is the public trust and confidence and the trust of road users not a priority to you, Rick? And this is a beauty answer. They repeat this for the next 3. This is not a Lagoima request. We are therefore refusing your request under Section 17E of the Gloima because the requested documents do not exist. That's because I'm asking his opinion. 5. After being informed, Rick, yourself being the acting manager of parking enforcement, then deny a request from us to discuss this matter. Why? This is not a Lagoima request and therefore we're refusing your request under Section 17E, blah blah blah. 6. Is it beneath you to speak to a taxpayer in relation to Auckland Transport's failures with parking? Given you're the manager, perhaps an underling could provide us with an audience to discuss these matters further. This is not a Lagoima request, we are therefore refusing your request under Section 17E. Oh my god, broken record. 7. Is it possible to speak with anyone from AT in relation to these unlawful issuings of infringements and refunding the 2 that have paid and voiding the other 9 infringements? And this is a beauty answer. AT only enters into communication regarding infringements that are issued to the registered vehicle owner. Well, I'm one of those 12 people. Alright, John? So therefore I am the registered vehicle owner, or one of them, that you issued the infringement to. And I have asked in writing for a meeting to discuss this. And I've been told flat out no. What are you afraid of? Trying to justify unlawful actions? Are you afraid that I'm going to pull you up on the fact that you can't see white lines in your own photographs? What is it? I'm somewhat confused, John. You know, is this an ex-police tactic of yours? Email dated 19th of February at 12:46 PM addressed to Rick, John, Shane and Customer Liaison Officer. 1. According to Auckland Transport Parking Induction Corps Manual version 3 August 2017, page 6 defines a road marking or surface treatment as a traffic control device. Is this correct? Yes or no will suffice. And he's responded with traffic control devices are a national requirement and signage and markings covered within the TCD rule, traffic control devices rule. Yep, I've looked at that rule, and in that traffic control devices rule, it says nothing about white hockey sticks being anywhere near broken yellow lines in the same spot. It says broken yellow lines, doesn't say anything else. Doesn't say there can be a white parking space with the broken yellow lines. Perhaps your engineering wasn't up to scratch there, John. 2. According to Auckland Transport Parking Induction Corps Manual version 3 August 2017 page 65 states that traffic control devices, whether used singularly or in combination, must contribute to the safe and effective control of traffic and must not dazzle, distract or mislead road users and convey a clear and consistent message to road users and be maintained in good repair. Is this correct? Yes or no will suffice. Again, a traffic control device must be interpreted correctly. What does it have to do with the interpretation? This is telling you what they must be. You're trying to say that I interpret it incorrectly? That I should have just flipped a coin and said, oh, well, I'll go with the white lines, or no, shit, heads, we'll go for the broken yellows? Because that could be interpreted 2 different ways, i.e. not conveying a clear, consistent message, i.e. misleading road users. I'm going to fucking beat this dead horse until you guys get it in your thick skulls, honestly. A traffic control device has priority rating. Safety-based signage and markings are first priority. In other words, the yellow lines, not the advisory white ones. According to Auckland Transport Parking Induction Core Manual version 3 August 2017, page 131 states in a red highlighted box that report any sign faults that you find. Remember, if there is no correct legal signage, there can be no offence. Do you, Rick, consider conflicting road markings not to be misleading? The issuing officer issued the safety-based offence correctly. So it's a safety-based offence and not a stationary vehicle offence? Which is it? You want to keep changing the lingo? I mean, you're saying things have got to be interpreted correctly, so what are you using? English interpretations, or are you using legal interpretations, Rick? Or John? Which is it? The issuing officer issued the safety-based offence correctly. No, he didn't, because there were white lines there. He didn't report the sign fault. No offence was there because of the misleading road markings. He failed. He failed to do his job correctly. The adjudication team failed their jobs correctly. And the prosecutor, come hell or high water, wants to try and carry on doing frivolous and vexatious litigation against me for something that never ever existed. No offence exists until filing a charging document. It's just an alleged infringement. It's only a notice. Do conflicting road markings convey a clear and consistent message, Rick? The issuing officer issued the safety-based offence correctly. The officer interpreted the broken yellow lines correctly. Did the officer see the white lines, John? Perhaps the fact that your initial photos taken on the 12th of October don't even show broken yellow lines. Otherwise, why would your warden, Stevie Baby, go back on the 15th of November over a month later and take 3 more photographs, which also show white hockey sticks and broken yellows? They clearly show misleading road markings. They don't show a vehicle committing an offence, and therefore are only relevant to the scene. They're only relevant to that location to show whether or not there was misleading markings or not. So your own photographs show they were misleading. Page 4. 5. Does the above photograph show correct engineering, Rick? The image above clearly shows broken yellow lines, which is a safety-based restriction. They also clearly show white lines showing misleading road markings, therefore no offence exists. Especially the bottom photo with the $60 trap sign I took and the revenue trap and chalk that I put on the sidewalk for you guys, to avoid any other road users being misled by your unclear message you're conveying. 6. If the above photograph shows correct engineering, then why did AT correct it by the 16th of January 2019? His answer: the image above clearly shows broken yellow lines, which is a safety-based restriction. It also clearly shows white lines, which you're failing to even comment on, John. The general maintenance of signage and markings is regular activity for Auckland Transport. I don't doubt that, John. So is regular maintenance and repair of misleading road markings. Did you fail to mention that, John? A. When did your unnamed operational manager and supervisor conduct this review? This review was completed after the customer service team received a large number of your YouTube clips. The review was completed the same day as a police incident report was compiled and presented to the police with the officer and supervisor. All parties viewed the YouTube clips. The date was the 11th of January. On that day, Rick reviewed the infringement with all relevant information. So Rick watched hours and hours of my video clips, did he? So Rick marched on down and compiled an incident report and spoke to the police, did he? Well, I'm going to show a clip very shortly of me going into the police station and asking them if there's anything open, any incident reports noted, anything at all. And the police basically saying no. And I didn't just check my name, I checked my daughter's name that you chose to go ahead and put as the customer information on the service report that I made. The only possible way Auckland Transport has my daughter's name is through the AT Hop card system, which I suspect you accessed to get the name and put it in. And I also believe, just like your wardens believe there was no unlawful issuing, I also believe that you have put my daughter's name on that details in regards to the service request to have the lines painted over and get shit fixed is an attempt to put fear and instill, because you're talking about making incident reports to the police with my daughter's name on it. My daughter has had absolutely nothing whatsoever to do with Auckland Transport or these, and you are retaliating because you allege that I have made veiled threats against the warden and his children. The only mention of the warden and his children I have made is that I asked a simple question: would Zane, and I forget his daughter's name, appreciate their father issuing unlawful infringements? That is not a threat. And if they didn't like his children's names being in a public domain, then I would suggest you not put them all over Facebook. Okay? I didn't put your children's name up there. You did. And it took me all of a few minutes searching to find them. Okay? And yes, I'm going to ask if your children have morals and would consider unlawful issuings of infringements to be a relevant question. No way do I make veiled threats. I don't threaten anything. I simply follow through. I would never have the intent to threaten or cause anybody to fear for their safety or their well-being in any way, shape or form. And that is nothing but a disgusting attempt by Auckland Transport upper management to try and shit stir and throw me off the fact that I'm going to court on the 1st of April because of your frivolous, vexatious and unlawful filings of offences that never existed because of misleading road markings. Follow your own rules. I mean, you're probably not used to a mere citizen challenging your authority like this, but I would suggest that you pull your head in. You have breached my daughter's privacy by putting her name and details on something that has absolutely nothing whatsoever to do with her. This is my opinion and information that I seek to impart in any form and in any kind I see fit. I suggest you go and check your own New Zealand Bill of Rights, Section 14. Okay, John? You're an ex-cop. You should know this. B. Did they review just the infringement notice or look at the purported evidence? The officer's infringement carries photographs taken at the time which clearly show the vehicle parked over broken yellow lines. No, they don't. Otherwise, you wouldn't go back and take 3 more photos in November now, would you? What is the purpose of trying to submit those into evidence? What's the purpose? Other to try and back up the fact that the initial photos with the private motor car associated with registration plate FAN 394 being parked there. The surface was wet, it appears. It looked like it had been raining. No lines were visible because of the extreme angle Stevie Baby went and took the photographs from. And when before the 11th of January, or after AT corrected the misleading road markings after the 15th of January, did they take into account CAS-965373-M4P0B1, which is a service request order they've gone and doctored my daughter's name on, where we made a service request and Auckland Transport corrected these misleading markings? And his answer was, repairs and maintenance are scheduled activity. You trying to say that that was scheduled activity? Of course it was, after a service request was made by me for that scheduled activity to happen. Don't try and make out that AT was going to fix it anyway. You did all of these requests and compiled all of this bullshit and did all of the bullshit with the supervisor and officer on the 11th of January, the same day I was standing outside that spot protesting for the second time in 2 weeks. Did I stir something up? Because for some reason 4 days or 5 days since that second protest, it was fixed. You guys got into line and corrected your engineering fault. The broken yellow lines were clearly visible, however slightly faded. Oh, so they're not clearly visible because they were slightly faded then, as per the officer's images. Which images? Because I can't see any yellow broken lines from the 12th of October, and I can see vague yellow lines along with white hockey sticks in his photos from the 15th of November. So which photographs are you talking about, John? Don't you know how to be specific? C. Why did Stevie Baby not report this fault opposed to issuing an unlawful notices? At the time of the issuance, officer did not believe that there was a fault with the road markings. Oh, okay. So, you didn't paint over them with black tar for any reason? You know, if they were okay, why aren't they still there? Why did you guys blacken them out? If there's no problem, why do extra work? Why waste taxpayers' money getting a contractor to do that? D. The fault was first informed by us on the 25th of October and received by Auckland Transport on the 29th. I would suggest you look at your draft exhibit list from the prosecutor to confirm that. It says received 29th of October. And in that letter, I point out there are white hockey sticks markings there with little X's on them, meaning they've got to be blacked out, which was never done. Why did it take 2.5 months to correct it? Auckland Transport AT has no records of a fault being lodged on the 25th of October. I can confirm that a request was created on the 4th of December. That's the day I spoke to Kyle. There was white hockey stick markings as well as broken yellow lines at the same location at the front of the courthouse. Please remove the appropriate markings. Well, there you go. That was on the 4th of December. And you yourself, John, have listed at least 2 infringements that were issued after that. So even after being informed on the 4th of December, you still are issuing unlawful tickets after being notified. That sounds somewhat fraudulent to me. Please remove the appropriate markings. And that was lodged by Kyle from my phone call, which is on YouTube. E. So we further request under the Official Information Act any and all public records to Auckland Transport, CAS-940216C5D8J4, service request and its resolution. Please find attached a detailed case report for case CAS-940216C5D8J4. Please be advised that details such as names have been redacted due to privacy reasons. Really? Well, you're supplying me the name of a customer that isn't me, so you're breaching my daughter's privacy by supplying me those documents without redacting her information, John. But all you've done is rejected one of your employees' names, and you've supplied me a customer's name that isn't me. So you've breached her privacy. What if it was some other person's name there? You've breached their privacy. You're supplying me their information and their address. Naughty, naughty. We trust the above information has addressed your request. Blah blah bullshit. Ombudsman. Same old jazz. If you have any further queries, blah 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 bullshit. Same old generic response. And that is John's answer. Next up, I am going to show you what they've done, what the complete case records, or how did he put it? The attached detailed case report for that service request, where I'm asking for them to black out those white lines, because clearly they shouldn't be there. If they're giving tickets for broken yellows, they shouldn't be misleading people. Bit of a rant this time, guys. That was a 6-page response from the head honcho of the parking compliance manager, the same ex-police officer that did his interview in regards to the Paul Martin T3 terror story that Fair Go did. So that's Johnny Baby, and his very vague responses, non-direct, and certainly not acknowledging any idea of the fact that there are white lines there. I'm thinking that they are all completely colourblind and don't give a flying f***. They mislead road users, and clearly by putting children's names to try and get a derived response, that's not on, and the police know as well. I call in there, I go to Auckland Transport in Henderson, which is only a registered office for them to collect money, according to Diane, and that recording is coming up, along with the recording from the police station in Henderson when I went in to check that there was nothing outstanding against myself or my daughter, given AT's claims of me making veiled threats to wardens and his children, which are grown adults, and me making supposedly comments. So perhaps they don't like transparency, perhaps they don't like accountability, perhaps they just like expecting everybody to respect their authority. I don't know about you guys, but if you get a parking ticket or a speeding ticket, you are presumed innocent until convicted and found liable upon conviction. Onus probandi, burden of proof, is for the person making the claim to establish every element of the criminal offence beyond the criminal standard of a reasonable doubt. It is not just a civil matter where there is a preponderance of evidence, there must be facts to prove it. AT have failed in this case. They want to be taken to the woodshed over this, which I am very happy to oblige, and on the 1st of April, His Honour Judge Kevin Glubb, who will be presiding over this matter, will be hearing from me, and I will be expecting him to act impartial and as an independent adjudicator in relation to the matter. I'll expect no colluding going on between the prosecutor, whose first duty is to the court, and any duty solicitor or duty lawyer that they want me to go and talk to, whose also his first duty is to the court, or any amicus curiae that Kevin might decide to appoint to assist him in regards to the matter. I've been through this before. I'm going to point out the basic facts, and I'm also going to point out the breaches of privacy that you have done. Absolutely disgusted with Auckland Transport. Oh, and I also went into, after going to Henderson AT yesterday, I went to AT's main office in Viaduct Harbour. Okay, so here I am at Auckland Transport in Viaduct Harbour. I signed in at the kiosk, waiting for John Strawbridge. Had nothing. So we will see them later. See ya. I went and signed in at the kiosk for John and waited and got no response. How they are so colourblind and don't consider two different types of traffic control devices or road markings to be not misleading, to be believed to be not faulty. I have had your own parking wardens look at the photos and say that's not an offence. There's misleading road markings. It should never have gone to court. So we'll just, as the police officer says, we'll just let the process go through its procedure. I've been through it before and I'm going to do it again, and I'll keep doing it, because everybody needs to learn how to stand up for yourself, how to use the own rules and legislation and regulations and procedure and due process that's there to help everyone, that gets ignored by everybody who's supposed to be following it. Catch you later, guys. See ya.
Load it, cock it, let it go.